The government's point person in the legal battle for the National Identification System NIDS, Attorney General Marlene Malahoo Forte, was again at pains to defend the proposal of the system. Among the concerns raised by the presiding judges surrounded why the system is so important, yet the government has not put forward any data showing they have lost millions as a result of not having a system like NIDS. Dwayne Anderson attended day 2 of the sitting and has this report.
Is there no other way? Chief Justice Brian Sykes may well have asked that question a dozen times as he addressed Attorney General Marlene Malahoo Forte in the NIDS case. The judge wanted to know why Jamaicans would be forced to give biometric data such as fingerprints under the proposed identification system. In one instance, the Attorney General stuttered out an explanation that not all elements of the data collection are forced, because things like blood samples may be requested by the state. But that explanation was also challenged. Justice Sykes explained that the word may as used in the proposal is the prerogative of the government, meaning the government may ask for additional information such as retina scans and blood samples. However, residents may not say no. The Chief Justice said they would again be forced to give these identifying marks if the state deemed them necessary, failing which they could be jailed or, as Justice Sykes puts it, prosecuted again and again and again until they agreed. The Attorney General, however, stressed that any data collected would be protected. She reminded the court that only an officer at the rank of superintendent and higher would be able to make a request for the information in the event it was needed for a case. This point of prosecution also did not sit well with the presiding judges. Justice Sykes in particular believes it was draconian to imprison a man who decided he wanted to exercise his right to live in the hills like a caveman and have nothing to do with government and their IDs. Justice Sykes explained further that if the government had shown it had lost $20 million or $40 million per year due to people not having an ID, then the system would not appear as draconian. He said, like voting in an election, persons should be allowed to make a choice to participate or not. In response, the Attorney General said it would be up to the court to decide when persons objected. She further contended that making a refusal a criminal offense is not as draconian because of the provisions regarding the type of sentence. Continuing on the point of persons failing to comply and give their data, the court wanted to know if these persons would then be denied of services which require a national ID. To this, the Attorney General said no. The matter continues on Wednesday. Dwayne Anderson, TVJ News.